You may have heard the term executor, and you may even be named one in someone's will. But what does this mean, and what does the job entail? Executor is a term that's sometimes used interchangeably with personal representative or administrator. There are differences, but for our purposes, we'll just use the term executor generically. Basically, this is the person who is responsible for dealing with a deceased person's estate. It's their job, and it is a job to manage all of the final affairs, usually of a financial nature, and distribute any proceeds that are left over to the decedent's heirs or beneficiaries. Let's discuss who's who. Please see my other videos for more detail. Let's call the person who died the decedent. This is Javier. He created a will and named his good friend Bella as his executor. In this example, Javier is unmarried and doesn't have any kids. His closest living relative is cousin Clara. Clara is Javier's heir by law. If Javier had no will, Clara would likely inherit his estate. However, there's Marco. Marco is Javier's best buddy from grade school, and they're like brothers. He named Marco as the beneficiary of his estate. This means that it's Bella's job as executor to see that Marco receives the final proceeds from the estate. Let's say Javier was actually married to Julie. It'd be common for the spouse to serve in every role. Julie would be the executor, she'd be the heir by law, and the beneficiary by document, whether by will or beneficiary form. Who has the right to be the executor? If the decedent had a will, the will lists the primary and hopefully some alternates. If there's no will or no one willing to serve who's been named in the will, the laws of the state set a priority order. Bear in mind that in some states, the spouse might have first dibs in administering community property assets. But if no one raises their hand accepting the nomination, any interested person can request appointment as the executor after certain conditions are met. What does an executor do? Please consider this a job. If you don't have the time and energy to devote to this job, decline and find someone who will. An attorney can do quite a bit for you, but ultimately you are the person who has to do the legwork and make the decisions and accept liability for it. The basic job duties in an uncontested probate involve getting appointed by the court, marshaling the assets and putting them into an estate account, dealing with creditors and paying debts, filing all tax returns, and lastly, dispersing proceeds to heirs, then closing the court case. There's a lot more involved if the probate is contested. How long does this take? In an uncontested case, it usually takes somewhere between 4 and 15 months. This would depend on how much time the executor has to work on the tasks and oftentimes how much the IRS needs. In an uncontested case, it's usually the taxes that hold things up, but this is mostly just waiting. Can you serve if you live out of state? Yes, you can. However, you may need to appoint an in-state agent who might be your attorney. And you may need to come to town to deal with significant physical assets such as houses or valuables, or you can hire locals to deal with it. Can you be paid? Yes, you can. Family members tend not to charge. However, they certainly can and are entitled to compensation because, again, it is a job that's time-consuming. If you want to be paid, keep detailed timesheets, and sometimes these need to be approved by the court. The executor is always entitled to reimbursement for costs advanced, such as legal fees, maybe mortgage payments, storage unit fees, etc. What if you decide not to serve? Immediately contact the person listed in the will after you and work with their attorney to file your declination or consent to the alternate's appointment. If that person says no to, keep working down the list, and if no one in the will can serve, consult with an attorney who may look to the priority in the statute. In our earlier example, that could be Marco or Clara. Lastly, professionals can serve, such as attorneys and professional fiduciaries or administrators. Bear in mind that professionals might decline if there aren't sufficient assets to be paid at their normal hourly rates. If you're named as executor or someone is asking you to serve, your next steps may include, number 1, deciding if you want the job. And if the answer is yes, contact an attorney who can assist you in your next steps. If the answer is no, decline immediately and potentially help find a successor. If you are holding an original will, the law requires that you do something with it. This might include filing it with the court or delivering the original to the named executor. There are penalties for failing to do so within a certain time limit. Thank you so much for watching this presentation of what is an executor and do I want to be one. As per usual, consult with an attorney in your jurisdiction for advice specific to your situation, and thank you for watching.